Welcome everyone to the third webinar in our third series of free webinars on remote interpreting in general and special topics in remote interpreting in particular is the subject of this third series. Welcome from all over the world. We have many hundreds attending today. I am Marjorie Bancroft. I am the director and founder of Cross-Cultural Communications, your host for this webinar. And we have our director of online training also assisting us today. For those of you who are new to our webinars, we have both Q&A and chat at the bottom of our screens. If you have questions, please, for the presenters today, who I will be introducing momentarily, please use the Q&A option. If you just want to share your general comments or where you're from or how you're doing, please use the chat feature, but change the setting. The default setting is messages to the panelists. Change it to all so that you're addressing everyone. That would be the panelists and participants option. Now, there's so much to remote interpreting, so we have a lot of different webinars with a lot of different specialized content. Today's one is a special area of legal interpreting, and it's called ADR, Alternative Dispute Resolution, and ODR, which is online dispute resolution, which, as you can imagine, is a very important topic, not just for legal interpreting in general, but the online version, thanks to the pandemic. As a reminder, this webinar has been approved for CUs from the American Translators Association, ATA, also from CCHI, the Certification Commission for Healthcare Interpreters, RID, the Registry of Interpreters for the Deaf, and for Washington, Pennsylvania, and Maryland state courts. Now, if you are attending live, you will get these CUs. Unfortunately, unless you attend live, we cannot give the CUs. And you don't have to worry, because 24 hours after this webinar, you will be emailed a link to download your certificate of attendance, and you will get instructions on how to request the RID CUs, which do require a separate $20 CU processing fee. These certificates are only available for attendees of the live session. Now, just so that you know, we are always eager to have suggestions and recommendations for other webinars in this series. Thanks to those recommendations, next week, for example, we finally get the immigration interpreting webinar that has been often requested. We are still looking for speakers for most common medical encounters in remote interpreting, how to increase your business as a freelancer in remote interpreting. And if you work in a call center or work freelance, those are topics that we're also interested in. Right now, I want to cede my place here to our wonderful presenters, who are Barry Roberts and Maria, I'm not a Spanish interpreter, Ceballos Wallace. They are really special presenters, in my personal opinion, on this topic of alternative dispute resolution, ADR in particular. Maria is actually a court-certified interpreter who is also a registered bilingual mediator. That combination of expertise, she's also, by the way, a certified medical interpreter, brings her and puts her in a very special position. Barry is a former attorney who, in addition to having chosen to specialize in this area, actually teaches mediation as a second language at the university level, and is an incredibly specialized in ADR person, because in the Los Angeles courts, who is she but, oh my gosh, you are the, help me out, Barry. I don't want to massacre your title. You are the
ADR administrator.
The ADR administrator. And so it is with great delight that I devote the rest of the hour to letting them do a really unique and unusual presentation on this important topic. Any questions before we start, Maria or Barry?
We wanted to launch a poll.
Absolutely.
Did you want me to go ahead and launch it?
And I'm sorry, it's launched. There you go.
Well, we wanted to get to know the participants today, so that's why we created this poll, right, Marjorie?
Absolutely. It's all about you is the title of the poll. So go ahead, everybody. Let us know where you're from. That's the first question. What are your specializations? And there you can check all that apply. Oh, it's coming in fast. Look, guys, legal, you got it. Like a huge percentage, although it varies, certainly well over half. Medical, also about half. We've got about a third for general community interpreting.
Number 3 is very exciting. The numbers are climbing. Have you had any training on how to interpret for mediation? That's wonderful.
20%. 20%. That is definitely more than I was expecting. That is exciting. And have you ever interpreted for mediation? Now, a lot more have than have had access to the training. Fully half. Okay. In any minute now, because people are still voting. I don't want to cut it off. This is unusual for our webinars in the sense that 90% so far are hailing in from North America. So we do have from Asia and Africa, and from Europe and South America, but mostly North America. And we do have some people who are not sure if they have had any training in how to interpret for mediation or have interpreted about the same levels. All right, I'm going to go ahead and end the poll and let's share the results so everyone can see. Are you intrigued, Barry and Maria?
Absolutely.
Very much.
Legal interpreting and medical interpreting tied, basically 59% each.
Woohoo!
And then educational interpreting, now this is a big surprise, a third have interpreted for education and just slightly more than a third for general community interpreting and almost a third for conference interpreting. All right, I really will leave you to now, but it's clear that you have an eager and highly relevant audience. Have fun with them.
Thank you so much, Marjorie. I'm going to share my screen and end the poll. Here we go. Welcome, everybody. This is an introduction to mediation and alternative dispute resolution, or ADR for interpreters. I am so thrilled that Cross-Cultural Communications and Blue Horizon have taken up this subject to allow us to share it with you. And as I said, my name is Maria Ceballos Wallace. I'm a staff interpreter in state court in DeKalb County, Georgia. I'm also a Georgia and Florida court certified interpreter, recently CHI, and of course, a Georgia registered mediator with training in civil, divorce, deprivation, special education, mediation. I'm also an instructor for the Georgia Commission on Interpreters, and with that whole combination of things, it's kind of led me to learn more about how I can share the information that I have with other interpreters and other professionals. I am extremely pleased to introduce you to my partner in mediation. Notice I didn't say in crime, Barry J. Roberts. She is a wonderful professional, and I'm going to let her talk to you a little bit.
Thank you so much, Maria. Well, as you all can see, my background is in administering court ADR, teaching English as a second language, practicing law, and also mediating. So it's just about everything except interpreting. So I apologize for everything I'm going to say that doesn't make sense to you, but fortunately we have Maria and Marjorie to clean up after me. But I'm going to try to make up for my deficit right now by telling you about our goals for today, which are two. Which are to help you understand the basic terms and concepts of, ready, ADR, CR, ODR, and also to help you determine if specialized ADR, ODR interpreting might be right for you. But from the poll, and I bet you already know quite a lot about this, so those of you who do, we have a question for you to answer, which is, Maria, do you want to put up the question?
I sure do. Just give me a moment. I'm having a little bit of technical difficulty here, but nothing that can't be solved any moment now.
And you know, some of you may not be able to answer our question quite yet till we explain it a little more. So whenever an answer occurs to you, you can just write it in chat. And here's our big question. Why do interpreters need to know about ADR?
Here
What
we
do you
go.
think?
Finally got it there. Sorry
Thank you,
about
Maria.
that.
No, that's all fine. So whenever an answer occurs to you, just put it in chat and we'll take a look at them a little bit later, and you can be sure Maria and I will have our answers as well. Okay, so Maria, how are we going to cover all the things we're going to cover today?
Well, thank you for asking that question, because what we're going to do today is we're going to start with the alphabet soup of ADR, CR, ODR, mediation, and we're going to delve deep into that so that folks can get an idea of what it all means and what it all means to them, not just in comparison to court processes and other legal processes that they may have encountered, but also how it affects and how it impacts the interpreter, in how the interpreter participates in mediations, contributes. And, you know, we are going to look at some of the real special, I guess the special characteristics that make mediation and ADR processes so different, in that you might want to get some training to become an interpreter who has specific knowledge in mediation. Later, we'll share with you some of what we have learned over our time working together and what we think you might want to know about interpreting and mediation, plus obviously let you ask us some questions, whatever those might be. In the meantime, what we're going to do is we're going to start giving you some information a little bit so that we can help you answer this big question right here. And I'm going to start with Barry by asking her to define this alphabet soup that makes up ADR, CR, ODR.
Yeah, I'd be glad to start digging into this soup. But before I do, the poll reminded me of something I need to say. Our focus today is on ADR in North America, specifically the US. And we understand that many of the things we're going to talk about would have to be adjusted depending on the country and legal culture and many other things. So apologies if this doesn't hit you quite right for your particular legal culture. It's one of my favorite topics, and I hope to look into it a little bit more. So this is going to be pretty US centric. So the alphabet soup, coming right up. Conflict resolution, CR. So this is a general term for, take a wild guess, resolving conflict. Very good if you got that right. Now, alternative dispute resolution, ADR, is the term we use in legal and court settings. And the way to remember that is that the alternative is to trial. So ADR refers to many ways to resolve disputes without going in front of a judge or jury. Online dispute resolution, ODR, is CR or ADR, now you're experts on those terms, with technology. So any synchronous or asynchronous way, which we'll talk about in a moment, other than face-to-face, to accomplish the purpose of resolving disputes, that's ODR.
Now, it sounds to me like there's several ways that this alphabet soup can take place and happens. Can you talk to us a little bit about the most common processes?
Yes, I'd be glad to. And I think it would be helpful to hear a little example as we work through these. So as you can see, we're going to talk very quickly about negotiation, mediation, mandatory settlement conferences, and just a touch about arbitration. So to help you think about the similarities and differences among these processes, I would like you to imagine that you are a tenant. You're renting a small house somewhere in, let's just say, the United States. It's the dead of winter. It's about the third day of the month. And you hear a sound you don't want to hear. I'm going to try to make this sound for you. Ready? Did you hear that sound? That is the sound of your landlord knocking at your door. And your landlord says to you, "Where's the rent?" And your response is, "When are you going to fix my roof?" And the landlord says, "I need the full rent." And you say, "Maybe I'll give you half until you fix the roof." So you see what's going on here? We are in a negotiation, two parties trying to work something out, not very well. But actually, they probably would come to some agreement. Most cases like this do reach some kind of agreement. But in this case, your landlord is just not getting you and you're not getting him or her. And so the landlord feels that his or her only option is to file a lawsuit against you. And this is going to be called an eviction or unlawful detainer lawsuit. So the court is going to eventually set a trial date. And while that's happening, the court is very likely to encourage you to try to work it out one more time with the help of a nice person, probably someone like Maria or me, a nice mediator, to help you to do what you could not do on your own. Because mediators have a lot of tricks up our sleeves, a lot of training, a lot of strategies, a lot of ways to help you see the situation in different ways. Now, this could happen before the trial, it could happen the day of trial, could happen in many ways. And there's probably a pretty good chance we're going to be able to help you do it. But for this example, we couldn't. So now we're getting closer and closer to trial. And it's very possible that the court is going to ask you to try to work it out one more time through what's called the mandatory settlement conference. This is very similar to mediation, but this time it's with a judge or a very experienced attorney we might call a settlement officer. And this could happen right before the trial or a couple of days before. And here we have a judge speaking with great authority about all the bad things that will happen if you don't settle. But guess what? It's still your choice. So what we have in common with negotiation, mediation, and MSCs, which is the question at the top, who decides? You and the landlord decide if you're going to resolve it, and if so, how. The neutral or the mediator has no authority to tell you what to do. Now, an eviction case probably would not go to arbitration, but just for the sake of this example, if it did go to arbitration, what you'd be doing there is presenting your sad stories, your facts, your evidence, your arguments, and maybe your bucket of water if you're the tenant, and your empty pocket if you're the landlord, to the arbitrator, who will make a decision, who wins, who loses, done. So as you can see, that is more similar to trial, which is why we are not going to say one more word about it today or possibly ever. So now you know more than most people in the world about negotiation, mediation, MSCs, and arbitration, how they're similar and how they're different.
That is great. Thank you for sharing that with us, Barry. So now let's throwing a little bit of a monkey wrench, the other bit of the alphabet soup, which is ODR, online dispute resolution. Obviously, we're going through unprecedented times with regards to the COVID pandemic. And now we're doing a lot more things live or a lot more things online. Talk to us about, how all of this fits in there.
Well, that's a very simple answer, which is all of it fits in there. All of the things we just talked about can be done online through Zoom, like we're doing right now. There are several other platforms, Court Call, WebEx, that some of you may be familiar with. It can be done the old-fashioned way through conference calls. It can also be done asynchronously through text, chat, or email, where people are sending in their offers, their demands, their proposals, their reasons in writing. But the most exciting form of ODR to me is through artificial intelligence and algorithms, which is actually happening now. It's going to explode in the future, where people are led through negotiation processes online through algorithms. It's absolutely fascinating. And it is true that all of this is absolutely necessary to be done online now, but this field has been evolving for many, many, many years. And it's a very important part of dispute resolution.
Well, Barry, before we go on to talking about interpreters in this field with regards to mediators, let's talk about how an ADR and ODR is actually different from the legal or the court processes, so we can get our benchmark.
Right. Well, anyone who's seen a trial on TV or in the movies knows that the goal is to win. So both sides want to win. We call this an adversarial or competitive process. Now, ADR and ODR might start off that way. I think we have a visual to show what that's like.
Yes, we do. There we go.
Very good. There we go. So a negotiation might start off like that. But the goal for a mediator or neutral, and even negotiation partners who know what they're doing, is to move from the adversarial mindset to a more collaborative, problem-solving, let's work this out together mindset. So the goal is everybody wins, or at least nobody loses. So that is really the main difference between legal and court processes and ADR, ODR, CR. Although perhaps that's part of the legal too.
And because it's a participatory process, what does it look like? What is actually going on wherever it is that you're having a mediation or a settlement conference?
Well, I wish I had an exciting answer for you, as exciting as what trials look like, but unfortunately, there's not that much to see. If you just walked by, you would see people sitting around a table talking, standing in the hall talking, on the courtroom steps talking. That's what it looks like. But if you knew what to listen for, what you'd be hearing is, with an experienced professional neutral, you would be hearing a very structured, yet informal, an open communication process that has a beginning, a middle, and an end, with guideposts along the way, with strategies, with particular kinds of language, which are the main one's called active listening. You would hear some monologues, you would hear some dialogues. There would be times people are together in a main room, either virtually or in person. There would be caucuses where people speak to each other privately. And there are documents, hopefully a settlement agreement.
So what about the benefits? I'm hearing that there's a lot going on, that it can happen at any stage, but what prompts people to go to mediation or to participate in this process that would benefit them more than going to trial?
That's a great question, because there are many benefits, not only for the parties themselves, but also for the court. And even without regard to court, if we're talking about community mediation or non-court settings, the opportunity to improve one's understanding of oneself and others and the situation are so powerful. But in terms of court ADR, we say that the benefits are that it's faster than going to court. It's a lot less expensive than going to court. It's certainly more informal. And that means that there's a lot less stress. And another reason there's less stress is that the parties retain control over the outcome. They're not sitting in the mediation thinking, I could lose everything, because they won't. The worst that can happen is they'll walk away and take their chances at trial. So the parties keep control over the outcome. And for many cases, for example, family law or probate law, and anything having to do with children, the relationships can be protected in ways they are not when people are trying to defeat each other in an adversarial setting.
Well, this leads me to ask you about what kinds of cases are going to be, what kinds of topics, what kind of cases are going to go to mediation?
Well, in terms of court ADR, just about anything that a judge or jury could hear could first be sent to some kind of ADR process. So that's from the smallest kind of small claims collection case to the kind of eviction cases we just talked about, all the way up to huge class action cases. It's also without regard to the court, there are many sort of administrative hearings or quasi-legal settings where, again, there's the option for some kind of third-person decision maker to control the outcome, a hearing officer, for example, or even a school principal, or to have the parties sit down and try to work it out themselves. So there's also in community mediation where I used to work and train, anything that a police officer might come out to try to resolve between neighbors could easily be sent to a community mediation center to help people work it out.
I always found it extremely interesting that mediation just covers so many different realms, the expected and, those that are, perhaps a little more unexpected because they're just tangential to the legal field. They're more community related.
That's so true. Yeah.
So this brings us back, Barry, to our first and big question. We want to know what our participants' final answers have been. Thank you for filling us in on mediation, Barry. So Marjorie, what do we have as far as questions from our participants, or answers regarding to this question rather? We're gonna
Did we
Unmute.
lose
Sorry,
Marjorie?
I just had to unmute myself. I'd actually like to start with a couple of interesting comments that we've had. I just got a message, you'd like me to do my video. Okay. There we go. Someone said, ADR, ODR looks like Teddy Roosevelt's policy, speak softly and carry a big stick. I just thought you'd appreciate that.
That's perfect.
I love it.
And other things, other comments that we received right at the start that, why is this important? There's many cases settle outside the court, so that these interpreters are finding cases are increasing. There's special rules that govern the process, which are quite different from court hearings, and there's special confidentiality issues, and legal interpreters are called often to participate in ADR, ODR. And someone wrote that it's a fair and equitable service to people of all walks of life. They said it's important because it's important to serve our LEP communities well, and the more we prepare the interpreter, the better service we provide. They said interpreters have a key role in mediation, so our knowledge in mediation helps the mediator and any parts involved in the mediation. And for impartiality, the interpreter must fully identify and mirror the mediator. These are really substantive comments that you got coming into chat. I was actually really impressed, and it goes on. Someone, by the way, said there's additional terminology and procedures, and many litigants do not wish their case to go to trials to avoid legal costs and expenses and other issues. Also, ADR and CR are less stressful, more amicable methods to resolve a dispute than actually going to trial. So there's a lot of people on this who really get the importance of what you're presenting on. And what it means during legal interpreting to interpret mediations before it moves into court and before a judge. So, and by the way, someone also mentioned that more and more interpreting services are often needed in these areas, which I think you two have also been observing independently.
Absolutely.
So in terms of substantive questions that are coming through, the first one that came through is, are interpreters required to be involved in conflict resolutions? Is that their job? Interesting question.
Well, we're going to start covering those questions in our next segment. But first, I want Barry to chime in a little bit about the comments that we received regarding the big question. Barry, what do you think? That was everything covered? Did you have anything you wanted to add?
Well, thanks. Thank you, Maria. As you know, I had a long list and I just was crossing many things off thanks to those answers. But I do have two left. One, and maybe you intuited, and it's too obvious to even say, is that ADR is a routine part of court proceedings at this point. When it started off years ago, as I said before, it was the alternative to trial, and it has become so routine and so institutionalized in our legal system that trial is now the alternative, which is fascinating. It's flipped around. So pretty much every case is expected to go through some form of ADR before a trial will start in many parts of the US. I can't speak for every part. So that's one reason. If you're going to be interpreting in legal or court settings, you can expect this to be part of it. The other reason, and this is a little more intangible, but from working with Maria and Marjorie, it's really become apparent to me that mediators and interpreters have so much in common in terms of trying to increase understanding in every sense of the word, but they don't know it, right? And so if they could just understand each other's roles and learn how to work with each other in sync, they could promote the goals of both professions and really empower LEP parties to have a meaningful place at the table. So it's a very important reason for both Maria and me. And now let's turn to Maria, because after all, she is a mediator and interpreter. We've got two for the price of one. So let's hear what she has to say. One question I have for you, Maria, is based on your experience in both areas, what would you do differently when interpreting in a mediation compared to court? Can you talk about that a little bit?
Well, generally, the first thing that I mention when I compare court and mediation is and you really can't emphasize it enough that anything that happens in the court, within the court process, is part of an adversarial process. And for the most part, everything that happens in the mediation process, unless it's an arbitration or finally the well, even in the MSC and the mandatory settlement conference, there is a certain amount of autonomy. So it's very collaborative, and that's very important, because that informs the interpreter as to what kind of standard of practice the interpreter is going to apply. We know that we have some specialties in interpretation, which include medical, educational interpreter, community interpreting, and those fall more along the side, let's just say, towards a collaborative, although let's be clear that there is a code of ethics and standards of practice that have to be applied across the board. But specifically, court interpreting is very, very regimented and very, very specific. So there you are, just there to even the playing field for the LEP party who needs to participate in the legal process. A mediation, however, is far more less structured. And it is more of a conversation, even though, as Barry mentioned earlier, there's specific guideposts and stages. And while in all of interpretation, the goal is meaningful participation, which is basically the of the Civil Rights Act that for meaningful participation in judicial processes. In mediation, which is kind of, it is in the legal realm, but it leans more towards community interpreting and the non-adversarial process. We also need to focus on communicative autonomy, and that's a concept that has been developed to explain the importance of the language access, language justice to the LEP participants, so that that person is not only able to hear, but they are able to effectively communicate their wants, their wishes, and really participate truly, rather than just hear and let the process pass them by. So those are the things that I look at in terms of ADR that make it different for me and how I approach it first.
Well, as a mediator, I'd be so excited to have an interpreter who could explain the LEP party's culture. So that would really help me promote my goals as a mediator. So I guess that would be one of the first things I ask you. I'm winking for all of you out there.
Yes, you are. For all
but
of those.
I'm gonna stand by that question. So what could you tell me about the culture of the LEP party?
Well, Barry, you're not the first mediator or attorney or basically any English speaker who's trying to communicate with a person who speaks another language who's asked me that question. And I'm sorry to say that the answer is that as an interpreter, I am not qualified to answer cultural questions. I am not a cultural expert. Frankly, the only person who's a cultural expert about that particular party you're inquiring about is that person, him or herself. We might come from the same region, we might come from the same town even, but we might have either different religions, different backgrounds, there might be all kinds of things which influence how we perceive our own culture. And so therefore, I am in no way qualified as a cultural expert. What I can do for you is I can identify any breakdowns in communication that are not allowing the conversation to proceed, and identify them, indicating whether or not there may be a cultural misunderstanding. And from there, I hand it right back to you. I pass the buck, so to speak, and I let you take it over, and I will interpret any dialogue that you would like me to interpret, so that you can explore the reason why the communication is breaking down. And you can ask those questions. It's so important, because as the interpreter, my job is to, especially mediation, my job is to make sure that I am as unobtrusive as possible, that I impress upon everybody, the parties, my opinions not at all, or my points of views, and that I allow the mediator to build rapport directly with the limited English proficient party, so that I really am the bridge or the conduit to that communication, as opposed to a active participant. It's not my job ever to hijack the mediation process.
Mm-hmm. Well, thank you for explaining that. And I know I'm supposed to appreciate that, but I have to say that it would still be very frustrating as a mediator who's new to working with an interpreter. Do you think most mediators would understand that distinction?
Well, I mean, I think that once you explain to a mediator that the best way for you to support the mediation process, not just the mediator, but both parties, is by using tried and true methodology that has been shown to promote this communicative autonomy, I think the mediator is likely to appreciate that you are really there as another tool that's in their toolbox to use, as opposed to as an active participant. So mediators don't if they're not trained, if they haven't worked with an interpreter, they might feel that they should subordinate their role to the interpreter, and it's the interpreter's job to tell the mediator that no, I am here as a supporting part. I may have some active parts, I may have some less active parts, but I am really here as a conduit.
Well, this is starting to sound a little bit more in sync with what I would actually want, but I think it's going to take some education and getting used to. It looks like we're going to have to do a training for mediators on how to work with an interpreter. But for now, we're focusing on the reverse and what interpreters need to know about working with mediators until mediators can get the training they need. So you've mentioned many of the challenges. Are there some more challenges that we need to become educated on by the interpreter?
Absolutely. And mind you, these challenges are not unique to mediation, but they present themselves in mediation in ways that can actually impede the process. So, for example, getting the parties to adjust to working together and through the mediator, getting them to adjust to pausing between sentences, getting them
I hate that.
I know you do. We've had discussions over this quite a lot.
I just wanted to interrupt you to show that I'm really hearing what you're saying.
I appreciate that. And it's really important because the consecutive mode of interpretation is the one that is mostly used in mediations, unless you make some other adjustments, be that using remote interpreting equipment for some monologues, or, just maybe doing some chuchotage or some simultaneous interpreting, whispering next to somebody. But generally, consecutive interpreting is the mode of interpretation that best suits mediation. And having the parties not talk over each other is obviously a requirement. In addition to that, we have to remain as unobtrusive as possible. So if we can address these challenges in advance with the mediator and the parties, then maybe we don't have to interrupt as much in order to do that. Now, interestingly enough, there may be some emotional times during a mediation, depending on the subject matter. And this isn't any different than perhaps a mental health interview or some other kinds of interviews, where the interpreter has to make some executive decisions within the given parameters that the interpreter is in, as to what mode of interpretation they should use and whether or not they should intervene or not. So all of these are all challenges. Like I said, they're not absolutely unique to mediation, but they will present themselves uniquely in mediation in specific parts of the mediation. So some challenges are more common to the middle or the beginning or the end of a mediation than other challenges.
That is so interesting. Do you think most interpreters would know what you just said and would know how to handle it, or do they need some kind of specialized training?
Well, I've got to tell you the truth that before I became a mediator, I thought that I knew what I needed to know about interpretation in mediations. And in fact, the fact of the matter is that when I became a mediator and I learned about all the different disciplines, that I learned about the process, the opening statements, the agreements to settle, the settlement agreements, the issues of confidentiality, I did realize that there were many, many nuances to not just to interpreting in a mediation, but to the actual mediation process. And that was really critical for me to think of how I could participate in some kind of training, not just for mediators, but also for interpreters, because here I had this dual role. Funnily enough, I actually had to think about, well, as a mediator, how will I work with an interpreter? I know how interpreters work, but what guidelines exist, if any? And the truth is that not a lot of guidelines exist. In Europe, there have been some academic journals and articles written about working with interpreters in mediations and ADR type processes. But in the United States, it's not really that common. So I really think that interpreters could benefit with training on mediation and the mediation processes, as well as the language of mediation. You're an expert in this, Barry, and the language of mediation is just so interesting. Active listening, reframing, just the way that things, the verb tenses that you use for hypothesizing or for, the what if scenarios, all of these things require a little bit of forethought in order to be delivered in a seamless way. So yeah, definitely. I mean, I'm still learning myself, I've got to say.
Well, I certainly am too. I have a lot to learn. But, there are also some particular terms like compromise, collaborate, which mediators just throw off their lips without having any concern about what's actually being interpreted. And it would be very important for the interpreter and the mediator to be in sync on what is actually trying to be conveyed. But I'm really jumping ahead of ourselves. This is one thing we would be covering in our training. Let's look at what else we're going to cover.
Absolutely. So from the perspective of the interpreter, what we're going to be covering is some of the things that I feel as an interpreter I would have wanted and needed to know. I'm very interested in knowing and understanding the nuance of the process so that I can determine what mode of interpretation to use at given times. And like I said, consecutive interpreting is going to be your default, but it's also important to be able to read the situation and position yourself accordingly, physically position yourself accordingly, as well as determine what mode you're going to use should the situation become emotional, should we have parties that just are unable to pause, etc. Site translations are also very important because the beginning of a mediation starts with an agreement to mediate. It starts with an opening statement, which may be available in writing in advance, or at least the points, and it ends, hopefully, in a successful mediation, it might end with an agreement to mediate, not including all of the documents that might have been presented in between in all of the other stages. So there's some challenges in terms of applying the knowledge that you have learned in the community interpreter and other training courses on when you should site translate a document, when you should not, when you should suggest that a translation be actually provided instead of a site translation. And the most important part for me is really, really understanding the process so that I can be as unobtrusive as possible, intervene as little as possible, but intervene effectively when necessary to promote the goal of the mediation, which is communication between the parties. So those from the perspective of the interpreter, wanting to know, wanting to get in, these are the things that I would have loved for somebody to have taught me.
And I would have loved to have interpreters who understood all that in my experience as well. And I just wanted to say about number 3, the interventions, my understanding is that very helpfully, you all use the term mediation or linguistic mediation to talk about interventions, which is why we are going to use the word interventions during mediation, right?
Absolutely.
Okay. I'll just say from the point of view of the mediator, what I'm hoping to convey is before we get to the specifics on the slide, which is generally the underlying spirit of ADR, ODR, and CR, the intangibles, the principles that will help you understand the context you're in. Because once you understand that, as I have been taught by Maria, the interpretation will flow. So that's underlying everything, these intangibles, which mediators love. But we're going to make it, we're going to go from that intangible to the tangible in terms of specifics about the language of mediation, some of which we've touched on, such as active listening and reframing, as Maria mentioned, and particular terms that come up all the time that have many different ways to be understood. We're going to cover the 3 stages of mediation, so you know where you are at all times and how to adapt. And for me, the main thing is how to work with a mediator, what to ask, what to tell in a briefing, in an introduction, maybe during a break. I think of this as the care and feeding of your mediator.
Excellent. So those are the things we've been working on that we wanted to share with you today. We see that there's an awful lot of questions and some participants have raised their hands. I'm going to stop the share for a moment, hand it over to Marjorie so she can lead us to asking and answering the questions that you folks have asked. Thank you for listening to us.
Thank you so much. Even without having personally interviewed the participants, I can tell you from comments and questions and chat, they have found this extremely informative and illuminating. So thank you from the start. There are so many questions that I've had to actually try and help and prioritize them for you. A question that came up several times was, and I apologize in advance if you've answered these questions and I haven't noticed because I've been so focused on selecting good questions for you. But again and again, we've had the question, which mode, and both in Q&A and chat, which mode you recommend and why?
Well, for the most part, the consecutive mode is the mode that I would recommend because it's the mode we use when there is a dialogue, when there's a question and answer session. However, the mediation does have an initial process, which is kind of like a monologue, which is called the opening statement for the opening statement that the mediator gives. And there is some leeway there that could, depending on the situation, depending on your rapport with the mediator, depending on the setup in the room, depending on whether or not you have equipment, or depending on the number of LEP parties that may or may not be present in the room, simultaneous may be used up to the point where there's a question asked that has to then, go back and forth where consecutive then takes over. So there's a possibility for that to be used, but it's really up to the interpreter and the mediator to look and talk about, like I said, the setup of the room, the number of participants in the room, and all of that. So I wouldn't categorically say opening statements are going to be simultaneous, because in fact it's entirely possible that it may not be possible for that to happen.
Thank you. And I want to ask a follow-up question from a really serious Indigenous language and Spanish language interpreter in New Mexico, where she says in New Mexico, interpreters are expected to interpret simultaneously with equipment for all mediations. Why is this not advisable? Very related question.
Oh, I don't think it's not advisable. I actually like the idea of using interpreting equipment for mediation. However, it's not always available. That's really the distinction for me. Not most freelance interpreters, many freelance interpreters that I know, let's not say all, many that I know don't own their own equipment, and by not owning their own equipment and they might be sent to a mediation, that automatically precludes that possibility. Many courts have equipment, many courts don't have equipment. And so therefore, if there is an actual rule, as a protocol where the equipment is available and it is the standard, I am completely in favor of it. I think it is the the less obtrusive method of all of the possible methods. However, I also think that we should keep in mind that there might be a possibility that, depending again on the circumstance, depending on whether or not the LEP party we're interpreting for is hard of hearing, which happens often, or the circumstances that are happening, there may be times when you do want to go into the full consecutive to make sure that the parties are not speaking too quickly, and that the nuance of the questions that are being asked and the answers that are being given to the mediator and by the parties does not get lost. But I definitely support using interpreting equipment. I think it is especially in COVID era and even before, I think it's critical to be able to use it and to know how to use it well.
And someone who happens to be a lawyer and interpreter mentioned, and to follow up with what you just said, I found that the consecutive mode also helps in the mediation, as it precludes people talking over one another, but also allows people time to digest what was said, which isn't always the case in mono. I guess she meant
monolingual, perhaps.
Yeah, monolingual must be what she meant. It's monolingual medication. I'm sure it's monolingual mediation. Do you also find this true?
I completely agree. I think that, like I said, I think that the consecutive mode is very useful for my personal preference is that if I could do the monologue with interpreting equipment or simultaneous, and the situation is appropriate for it, then that would be a really good way to start, because then the person could hear the entire opening statement without any interruptions, and everybody could hear the opening statement without any interruptions. I do prefer the dialogue to be in the consecutive, because that gives everybody an opportunity to participate, to think, and also slows the process down. When people come into a mediation, it takes a little while as a mediator to get them to calm down and to just, to become part of the process and to buy into the process. So if we are rushing them with everything in simultaneous, it may not go the way we want it to. And here I am speaking, with my dual mediator interpreter hat. But please know that if I were mediating, I'm mediating, and if I'm interpreting, I'm interpreting, and those are two completely different things. And I I do disclose that I am a mediator when I'm interpreting for a mediation, and I only disclose that for the purpose of letting the mediator know, so that they know that I understand their process.
You just actually answered another question.
Oh.
So thank you,
Marjorie,
for that.
I wanted to say one thing about that, because I think that question was getting at something really deep, which is that even without interpreting, the slowing down and the paying attention to every question and every answer and having that pause would actually benefit mediations, even if everyone's speaking the same first language. So I thought that was a pretty astute question that came in.
I thought so too. Here's one for you, Barry, that you may also find very interesting. She says, I find a lot of the language of mediation also corresponds to the language of psychologists in many ways. Do you find that true? Yes, and
we actually have a little saying that mediation is not therapy, but it is therapeutic. So
that's a great saying.
So we share a lot with that realm, especially when it comes to active listening, where our focus is on really trying to understand empathetically where someone else is standing in their shoes, which is what I know interpreters do as well. So I love that question, because we're going to see overlap in so many different areas.
Yeah, absolutely. Here's one. Hello, do interpreters get the request to interpret in ADR through the courts or by an ADR office? Thanks.
Okay, Barry, I'm going to let you start with that.
Oh, Marietta, you took my line. I was going to let you start.
Okay. Well, one of you start, please.
What was the question?
Do interpreters get the request to interpret in ADR through the courts or an ADR office?
Okay, Barry.
There's so much variation. There's just no one answer, and it's whatever answer is, it's not going to be one we would like. So interpreters are not necessarily required for all kinds of ADR sessions, even at the court, which is why, unfortunately, some let parties end up in trial where they will get an interpreter. So we need to work on this.
My answer to that is that it really depends on the state in which you are. In the court system that where I interpret in Georgia, all court-related mediations use interpreters when necessary, and this case might be rescheduled if an interpreter is needed where a case where they did not know that they needed an interpreter. Having said that, how that interpreter gets to that courthouse depends again on how that courthouse actually hires interpreters. Do they have staff interpreters such as myself, or do they hire freelance interpreters either directly through their office of their administrative office of the courts, pardon me, or whether they actually have contracts with agencies that supply them. So you're going to get work in mediations either directly through attorneys whom you might work with, you might get them through community centers, you might get them through agencies, you might get them through the court systems. It's pretty much the same way as you would get any other work that that you do, whether it's for an IME, an IP, or anything, whether it's, you know, educational, medical, or court or legal related.
Super. Are there any disadvantages in ODR, even though technology is helping it in the current situation? Mediation involves emotional dialogue too in person.
I would
No
have
kidding.
to agree with that. There's not one process that is one size fits all that's always the best. Not even ADR or ODR, because sometimes a trial is what's needed. Someone has to win and someone has to lose. So nothing is always. So,
but in terms of ODR, are there
Yeah.
any specific disadvantages?
well, just what you were getting at, Marjorie, exactly, the questioner, the face-to-face emotion, sharing of opinions, problem solving, everyone in the same room at the same time. There's really no substitute for that, unless that would actually not promote working together in particular cases, right? So we can imagine, for example, custody battles or will battles among adult children. They may need a little space. On the other hand, they may need to be brought together. The other thing is with ODR, you're not always sure exactly who's who and who's where and if it's being recorded. So there are some challenges with confidentiality for one thing. And it can be a little unwieldy if you have attorneys and parties and interpreters and mediators and you have to share documents. So all of that needs to be really top-notch technology to make sure all that works.
I wanted to add, Marjorie, that with ODR, I mean, recently I've been involved in a really interesting project here in Georgia, which is the judicial COVID task force for the Supreme Court in creating regulations, not regulations, but best practices for working in COVID times. And obviously, this has impacted how we do remote interpreting and also how we provide any kind of legal service through the Zoom and other video platforms. I think that there are some types of cases, as we highlighted earlier, that might be suitable. That there may be a landlord-tenant case, maybe cases that are really about facts, maybe small claims courts, cases that are really about facts that that maybe don't require somebody traveling from New Jersey to Georgia and back and forth, and those would benefit from, just like simple interpreting assignments where somebody is scheduling an appointment or somebody is having some information read to them, or they're having a conversation with somebody. So I think that there's probably a guide. There you go, note to Barry. There's a guide of the types of mediation and mediation related events that should be promoted more in ODR, and then others that really should not be. And then by that same token, which of those should include interpreters and which ones of those should then go to in-person ADR versus ODR, because the interpretation factor complicates the situation. So this is a new field for everybody, I'd say.
Well, obviously there are way too many questions for 1 hour. This is always the case with these webinars, maybe especially true here, given the substantive nature of the questions. some of those questions I happen to know you're going to answer in November. So I don't know if you'd like to devote the last minute just mentioning what the two of you are up to on our behalf in November.
Absolutely. Barry, would you like to start?
Well, we have prepared 2 4-hour sessions and a 2-hour, what we're calling it, take-home self-study. We went through the points before. We're very excited about presenting this to interpreters. Speaking as a mediator, we need you for many of the reasons we mentioned and more that we didn't have time for. So we hope to give very specific, interactive, practice-based training. So you know, if you walk into a mediation, you're going to know exactly what to do before, during, and after, very specifically.
Absolutely. I'm going to post a little bit of information here for those who are interested in getting to know more about what we're going to be doing. This is the link. I just could not be more thrilled about the opportunity that presented itself through CCC, who actually put Barry and I in touch, and we have just been just partners in mediation ever since. I think that the course that we're going to give will give people an opportunity to learn and to brainstorm, which is also another mediation term, to brainstorm through through possible scenarios in advance before they actually end up being in them. And as an interpreter, I know that that is something that I wish, and in many scenarios, any scenario that I go into that is new, I wish that I had an opportunity to have somebody say, hey, you know, this is likely to happen, this is possibly going to happen, and when this happens, don't freak out. Just, you know, take a breath and go through your Rolodex of information that you have, everything that you've learned from the community interpreter, from language of justice, from your court interpreting seminars and everything, and just go in there and then find exactly the right way to do it. This will be a bit of a way that you can you know, have your notes, have your cheat sheets, have your note cards and information, so that you actually know what you're walking into, and you can address the expected and be prepared for the unexpected. So that's what we hope to share with you.
I'm sure if you had a chance to look at the chat, you would see many, many grateful participants. Thank you both so much, so deeply, and so tremendously. This is one of the most informative webinars I've personally seen, or any presentations on a very specialized aspect of legal interpreting that I think for most people is pretty hard to understand, to absorb, and you've made it all sound so clear and so straightforward. I will be happy to stay on and answer any questions that anyone has about the course, about our other programs, or even about some aspects of this. I'm not going to actually answer specialized questions about ADR because I am not a specialist in that. But you two are free as the day. You have more than earned, like, to rest of the day. I cannot thank you enough, both of you, Barry and Maria. Thank you tremendously. Have a wonderful rest of your day.
Thank you, Marjorie, and thank you, everybody.
Thank you, Marjorie, and thanks everybody for joining us. We look forward to future webinars.
Take care. I do see that there are questions about